The impact of the Consumer Protection Act on the medical care services. The Consumer Protection Act, also called the CPA, applies to every transaction concerning the supply of consumer goods and services for gain. As healthcare has not been exempted, the term service applies to the consultation and treatment of the patient, including performing operations, and the term goods apply to both medicines prescribed and any devices or consumables used when servicing the patient. Healthcare practitioners, as well as hospitals and other juristic persons providing healthcare, thus qualify as suppliers, and patients as consumers in terms of the CPA. The Act creates 8 fundamental consumer rights. The right to equality. All patients should be regarded as equal and receive equal treatment. The right to privacy. Information regarding the patient is personal and confidential, and examination without consent would also infringe this right, which is in addition to the rights provided by the Constitution and Health Care Act. The right to choose. The patient may decide for himself which service provider to use, what types of treatment he consents to, and has autonomy and self-determination regarding choices relating to his body. The right to fair and reasonable marketing. Marketing strategies may not mislead or deceive the patient. The right to disclosure of information. The medical practitioner must inform the patient fully of the nature and risks of the proposed treatment, and this may be the most important right when regard is had to the informed part of the consent requirement. Closely linked hereto would be the right to fair and honest dealings. The patient may not be forced or tricked into using a service or purchasing a product, which is often the case with uneducated patients who would not necessarily understand procedures unless they are properly explained in plain language. Codes of ethics which medical professionals are bound to adhere to further assist in preventing unethical and unconscionable conduct. The right to just and reasonable contract terms. Even though the Afrox case by the Supreme Court of Appeal is still law, it was decided before the CPA came into effect and have in effect been mooted by academic writers. It would thus appear that exclusion clauses which unfairly, unreasonably, or unjustly protect hospitals or medical practitioners from liability for death, bodily or psychological injury may be declared invalid, not binding or unconstitutional by courts in the future. The CPA further states that any term limiting the consumer's rights must be in plain language and their attention drawn thereto. Some clauses would even qualify or be presumed unfair or unreasonable automatically and be found to be unenforceable. The right to fair value, good quality, and safe goods. The patient has the right to expect that goods like prosthetics and pacemakers and equipment are reasonably suitable for their purpose, is in good working order, free from defects, and usable for a reasonable period of time, and creates implied warranties as well as no-fault product liability in certain circumstances. Services rendered are also to be of good quality, and the CPA provides remedies in addition to those available at common law. Remedies available to the patient in terms of the Consumer Protection Act. A patient may refer his complaint to the National Consumer Tribunal, the National Consumer Commission, or an alternative dispute resolution agent. It is, however, advised to rather have cases investigated by the Health Professions Council or similar bodies specific to the relevant provider, or heard in a court of law, as those who sit on these consumer fora will probably not be able to fully understand the technical complications and intricacies related to medical cases, and thus have difficulty in deciding on medical negligence.